Now back to the show. This is The Law Show on CL 650.
Good choice, Dwayne. Yeah, that's Chicago. If you leave me now, family law is what we're talking about. Perfect choice, and this is The Law Show on CL 650. We talked a lot throughout the show already, and I'll reintroduce my guest, David Halkett, partner at McQuarrie Hunter, and Sarah Morse here, the experts. Now, this is a tricky one. You have a relationship where a couple is breaking up, and one claims there was some kind of abuse, whether it's physical or mental abuse, to the other. How do you square that? Like, it's a he said, she said most of the time, isn't it? Unless there's been a track record of calling the RCMP or whatever and having a kind of orders in place.
Yeah, it's a difficult situation, Zach. We under our act, we the new act came in 2013, the Family Law Act, and it's specifically a factor now in determining custody issues or guardianship and parenting time under the act. It used to always be a factor that we'd always discuss, but now it's specifically a factor. And we all think of abuse and abusive families as being physical.
Mm-hmm.
But in my experience, it's not that many have physical abuse and that have come to me. A lot of it is emotional and verbal abuse. We also have financial issues. So say, for example, you refuse to let your spouse spend any money. You control their finances. That is abuse. Also, if you say, I'm married to Sarah, and I'm saying you're not talking to any of your friends. You control everything. The minute they're on the phone, it's like, what are you doing? They're go online. You're looking over their shoulder. That's abusive as well. And so we have to assess that at our meetings. So we have to ask our clients, was there abuse, and explain what abuse is, and go over that way. And then we also have to determine, because often they'll say, oh, there wasn't. Or they'll say what it was. Well, how does that affect it? How does that affect the situation? And we have to determine whether or not we can still settle it through mediation or non-court related ways if they can sit down and actually get a resolution. Just because there was violence doesn't mean you can't resolve it out of court. It just makes it a little bit different. But you are right, there's a lot of he said, she said. We've all had to act in matters where one party has said the other's been abusive, and your client says, I wasn't. Here's my explanation for it, or she says, here's my explanation.
Or you might have one relationship where somebody feels that that's abusive, and then you have another relationship where that's just the way they communicated with each other.
Well, exactly. And I've told Sarah the story before. I had a client once. It was a guy came in, and I asked about this, and he said that he'd been abused. So I asked him what was happening. He told me what was said, and from his perspective, that was abuse. And myself, I was thinking, my wife says worse to me, right?
Take out the garbage.
But it's very subjective on the emotional and the verbal abuse, don't you think, Sarah? What's abuse to one is not to another.
Yeah, I mean, it's like thinking about criminal law and the thin skull rule and all of that. I mean, you take your victim as you find them. I mean, that's very relevant in family law. What one person hears is going to be completely different as to how someone else hears that. So you really have to understand the family dynamics and understand your client to know what it is.
Could you use the argument that he's just a crotchety guy and he's grumpy, but they've been together for 25 years? Well, you kind of knew, how could you say he was abusive? You were with him for 25 years and he was grumpy the whole way through, right?
Yeah, well, you can, if it was a situation where it was never an issue before and only became abusive after, you might be able to make that argument. But there's also the counter argument that you stayed with the person for financial reasons and for the children, and you put up with a lot for a long time. It's very difficult because the research shows that if you minimize what the violence was to the person, you may be re-victimizing the person again.
Yeah, a real sensitivity, right?
So it's a tightrope you have to walk as the lawyer when you're acting for the person accused of the abuse in a domestic situation. I had to go through a long trial like that a while back, and the other lawyer said to me, well, I told my clients you were a lot nicer than a lot of other lawyers would have been. I put my client's version to them. I argued to the judge it wasn't abusive in an overall sense. But it's a tough one. How do you do it? The physical is easy to deal with because often there has been RCMP complaints.
And
there's
charges.
been charge or a peace bond or something, which is evidence that there was violence. the verbal is very tough to deal with.
But how does somebody that's mentally or like say someone is controlling, always watched who you talked on who you're talking to on the phone, or who are you texting, all of those sorts of things. Who are you going out to visit, or the grumpy guy who was always crotchety throughout the whole thing. How does that ultimately affect the end result of the divorce? Like, what bearing does it have on dividing the assets, is it mostly around children?
It has a bigger factor on children, because it is a factor specifically. Does it affect the ability to parent the child? Was the child a witness to the abuse and the violence? That's a factor. It can also be a factor in spousal support. For example, not so far that behavior causes one to get spousal support, but if as a result of abuse you're incapable of working.
Or they wouldn't let you out of the house, right?
Yeah, and so you have no skills, and now you've been driven down to like having no self-esteem. That can be a factor. In terms of division of assets, it's not really a factor in how it's divided, but it's a factor in how do you resolve it. If someone was abused so much that they can't be in the same room with the other party, they couldn't make a fair resolution, they just want to cave in, then mediation may not be appropriate. What our job as a lawyer is to assess whether or not, with appropriate advice, appropriate disclosure, parameters in place for mediation, whether the mediator goes from room to room, the parties aren't together, if a fair settlement can be reached, then we can still try mediation.
Now, do you find, Sarah, dealing with, you said in the previous show that you have a large section of women that come to you because you're a woman, obviously, talking about breaking up and separating and all that sort of stuff. Do women cave in quicker than men when it comes to these issues, or do they get a steel rod up their back and say, no, I'm going to fight?
That's starting to be more and more my experience. I do certainly have the clients that just they're feeling as though they've just come out of this and they just want out as quickly as possible. So not that they cave, but they're willing to compromise because they just want a clean break. They just want out. But I do have other clients coming out of what they term to be fairly abusive relationships, and they want it all. They want payback. So it really depends on your client. It's very individualized.
Yeah, well, what in those cases, I've had that too, where the person said, like, I've been abused for so long, I'm finally standing up for myself.
Yeah.
And they think any compromise is then
Caving
being abused
in,
again. And of course, if we're acting for that person, we still got to say, look, you can take this principal position, but it's not going to be worth it for you in the end. It's still our job to say, yes, you were abused. Yes, it was the behavior that happened during the relationship was terrible, but doing this isn't going to be in your best interest to take this position.
So when you get someone comes into you and they really are aggressive, they're very aggressive. I really want to take this person down. I just hate them now, right? And so how do you talk them down from that? Because as you said, it's not the best way to go about it, right?
Well, you have to be very understanding. I think you have to be very compassionate, and like David and I both said about them coming in and venting and allowing them that time to do that. But then our job is, and I'm sure David does this too, but he can speak to this, but I take the position with my clients that, listen, I've got to tell you this is how the law works, and looking at everything, I'm going to tell you the good, the bad, and the ugly.
Yeah, exactly. Like, I may say, look, yes, what happened to you during the relationship was atrocious. You shouldn't have been beaten. You shouldn't have been abused, and all that stuff. But in the end of the day, that's not going to get you more out of the house,
right?
Potentially.
And like, you could eat up the equity of the house by
exactly.
doing it.
You can fight this all you want, but it's not necessarily. So I think what happens when they first come in and they're coming out of an abusive relationship, they're either, as Sarah said, they've got the iron rod up their back, they're really going to fight it, or they're like a pool in the corner that you have to get strengthened. But over time, once they're away from it, they do come back more to the middle, and that's when I think you can get down to settling it.
Yeah, it's sometimes timing. I mean, I think one of the biggest things we've always talked about is a case will settle when it's supposed to, when the parties are ready to settle, when they get to that point, they're able to let it go.
Now, do you have people come to you and they're in an abusive relationship and they come to you and they say, I need some help with some kind of protection? And what do you do?
Well, certainly there's protection orders that are in place. What I tell them, if there's physical violence, call 911, and the criminal system can actually deal with you a little bit faster at times. But you certainly can go and make what they call without notice applications in court. Provincial court can deal with them as well, where you get a protection order, so there's no contact anymore. You get the person out of the home. And so you can do those on an emergency basis when absolutely necessary. And there's no other option to deal with it. Sometimes clients have gone down and they've gotten the order by themselves. They've gotten like free advice at the courthouse and then come to us with the order in place. And so protection orders are useful as a tool, but
having that record with the police, having a record of calling the police is a good idea.
It certainly is useful, although that can also be sometimes people will make phone calls when there's not a valid situation. It's good to have the protection order. It's registered with the RCMP and with police enforcement, and there's an office in Victoria that actually keeps a list of all the protection orders. That being said, a piece of paper has never stopped
somebody from being violent. Yeah.
And the irony of them, in my experience, is the protection order protects you against people who wouldn't do it, something violent, once you've separated, to you. It's not going to stop someone who is a stalker, a psycho stalker, who's going to do something to you anyway. And the irony also is that often violence explodes a lot at the time of separation, and then again at settlement.
Well, and that's when we did our family violence training for mediation. That's the biggest indicator of violence, or when it happens, is upon separations. Yeah. That's the can be the scariest point for someone that's coming out of that type of relationship.
When we come back, I want to pick up on this and talk a little bit about false claims as used as leverage, and you've seen those sorts of things. When we come back, talking about family law right here on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.